You need, sorry, you do need to go.
So I don't really have any updates at this point, other than the fact that I did have the property surveyed, as was requested by one of the abutters. Other than that, the project, as on my end, has been going forward as planned. Of course, awaiting your decision. Other than that, there's really no new information other than what was presented at the last meeting. So, thank you.
Thanks.
Excuse me, just a minute.
Now,
Excuse me, Mr. Chairman.
yes,
I believe we ended at a certain point last meeting with regards to a big question that we were waiting to have answered by the attorney before we were able to actually go any further. That was keeping us from making any further decisions.
okay.
So-
That would be fine if you want to bring that. What was that question?
There was the question regarding public safety, I believe. That was the issue. And our question, and there may have been another issue, but we had questions that we as a board were going to feel comfortable with being addressed by the town attorney to clarify various aspects of the project that we questioned as far as being a decision we could make without
Okay.
making a decision that in future could come against the
Yeah.
town in any way. So we were waiting on that.
Yeah, well, does the town attorney, do you want to do that now, or should we wait till the very end? Because what I was going to do is have each individual go down and give their concerns and questions, and then go to Scott Vorshak, and then Mary Costigan, the town attorney. Is that all right with you, or do you want to start with that?
Well, I was thinking we had already heard each of the board members with what we had so far. And we were waiting on that information to be able to make further decisions.
Okay.
So I think if we do that, and maybe if there's anything further that the public wanted to add before we can actually
Okay.
talk
Well,
about it and make any
okay.
decisions on our part.
Well, would you want to pose your question to Mary Costigan, and maybe she can answer that?
I'm going back to the last meeting. There were questions. Do we have those as part of the meeting minutes?
I have not had time to do minutes, not this time
I
of
think
year.
I can help you though.
Okay,
with-
I think Joanne, you want to take that?
I can try to.
Okay.
Mary, what we were trying to understand is the driveway and the plumbing, all of that's been permitted by the state. So there was clear concern about safety on the road and how the driveway is laid out. It was very confusing as to whether we even have the authority to overrule the state if they've issued a permit for us to step in and say something's unsafe at that point, and who's liable if we don't say it's unsafe.
Yeah.
Can that come back on the town, or how does that work?
So the only, is safety, let me just ask this question, is safety a standard that you are reviewing? No. Okay.
Excuse, there was, what wording, we were questioning a particular wording
Okay,
that
and what was that?
we weren't sure if that safety came under it. And I think,
Yeah.
I think it was public health.
Public health.
Didn't
Okay.
say
Right.
safety.
So kind of, it's a tiered question. So the first question is safety even a standard that you're reviewing? It seems like the answer is no, because it's not public health. But even if safety were something that you were to determine, you would then need some sort of objective standards that you were looking at. So there are some instances in some towns that have their own driveway standards in addition to what DOT does. So the answer to your question is it doesn't sound like you can deny a permit based on safety for driveway because you don't have your own standards. But just to give you an idea, generally, if you have a standard, if you have a review criteria of safety, you would need some objective standards to review to make a conclusion as to whether it's safe or not. When, say you had a standard, a review criteria, if you did not have your own standards, you would actually rely on DOT's issuance of the permit as evidence of safety, because DOT has its own standards. And your other question as to liability, if there were some accident there, you are not making any judgment as to safety, that's all DOT.
And I
Very
think it
good.
was,
Okay.
choose our this was on a state highway, therefore town of Raymond doesn't issue a driveway permit. That's why it went through the state.
Yep.
Otherwise, there would be somewhat of a criteria on that.
Okay. So it seems,
Okay.
just to clarify then, what's before us is a change of use. Whether we can grant a change of use on a
Yeah.
known.
The question that came to me earlier too was what should have been also added in there is because it's a non-conforming lot, that it should have been I talked to Phil, but I didn't get a chance to be in contact with him today.
Okay.
That it should have been also a variance for lot frontage.
Is it,
He's going from it'd be a 2-unit.
yeah, but it's a non-conforming lot of record,
Mm-hmm.
then he doesn't need a variance.
Okay.
He would only need a variance if it was a new lot, but if it's a grandfathered lot,
Okay.
he doesn't need a variance.
That was my
Okay.
concern.
Okay.
Would
Okay.
you do you have any questions you would like to ask?
No, pretty much everything that I had questions about was just taken care of by the attorney.
Okay. Do you have any questions?
I would like to say that Mary has answered the big question I think that we all had. But I really, I have trouble getting through my head that, you know, if there's a safety issue involved, that there's really nothing we can do. You know, it says in our books that, you know, we're responsible to improve and enhance the quality of life in Raymond. And if there's a traffic issue, particularly where there's beach and children involved, it just seems to me that our hands should not be tied so tightly.
Right, well, the solution to that is to have Scott talk to the Board of Selectmen you need, and at the next town meeting, to propose an ordinance that gives you some review criteria regarding safety, but without an ordinance that gives you that authority, you just don't, your hands are tied.
Thank you.
Mary, I just wanted to be sure, I'd sent some questions to you, and on this one where it's a change of use from a non-conforming use to a meeting place, and it's in a residential zone, changing it to a residential, so that's a conforming use.
Yeah,
We don't have to consider hardship or anything like that under this, correct?
correct,
Okay.
yeah.
Okay. And then I think, Scott, to you, just, I know there were concerns about parking and the boat launch. No one yet has come forward and the planning board never put any stipulation on the boat launch that they get so many parking.
There's actually no parking on either side of that road
Right, okay,
officially.
okay,
There's no sign saying no parking on there, but there really isn't any parking on either side of that, except for there is a little parking lot that has been there, and I think
For the
it's.
beach area itself.
Yeah, and that's it.
and
So you
for
would-
someone to use that lot to live in, we have to allow them to have access to the lot, is that correct? To drive in and out of it, or?
Well, that's what they get when they get the permit from the state that allows them
Right.
to egress and ingress from that property.
Okay, thank you.
Okay. I have no questions. Do you have any further questions?
No, I don't have any further questions because the question that we were posing as far as liability of the town of Raymond in case anything happens in the future, should this be approved, there is no liability to the town of Raymond because it was a DOT approved permit.
Well, not even that, but there is no liability. There's the Maine Tort Claims Act, and you're protected against decisions made in the normal course of government, so.
Okay.
Okay. Scott Vorshak, do you have any comments you would like to add?
No, not at this, no.
Okay.
I think we've done, followed through. My concerns was just on that, on the road frontage, but that's been answered, so other than that, I'm okay.
Mary Costigan, do you have any as the town attorney?
I do not.
Is there anyone that would like to make a, what do you call it? A motion.
Or should we give the public a chance to make any more comments?
We,
I'd just like to ask a question.
we asked them, do you want to make,
I just want to ask a question.
all right, go to the,
Address through the chair,
The question I had was setbacks. And when I went online and went on the Town of Raymond's web pages, it says from the property line, not the road, back is a 20-foot setback for residential, but it's not a 20-foot setback.
Yep.
Is that part of the variance, or?
Well, what it is that lot is a non-conforming lot. In other words, it meets no current standards whatsoever. The setbacks, front setbacks, side setbacks, and even the rear setbacks right now, it doesn't meet. And as long as they don't expand that structure to make it more non-conforming, they're okay to keep it as is. Or they could make it smaller.
Oh, okay.
But yeah, it's an old lot. Back in the day, so to speak, it might have been conforming at the time, but they look at it now as a legal non-conforming lot.
Okay,
Or
so-
it's legal, but it just
So
doesn't meet any of the standards.
it's a residential structure on a non-conforming lot,
Well, the structure itself is non-conforming also.
but it's going to be a residential structure.
It doesn't matter, when you're talking about setbacks,
Yes.
it typically doesn't, unless your ordinance has a different setback for commercial or residential, it's the
does say that.
setback for the structure. And if you have a structure that's been there since before the 20-foot requirement was created, you're grandfathered.
But it does say online that there is a residential setback.
Right, but
And
the-
there's a business,
The
commercial setback.
building
Is
was
okay.
there
Okay.
before the requirement, so it's grandfathered.
Okay,
That's it.
that's my question.
Yeah.
would you go over to the, state your name and tell us what your concern
Yeah, my name is Greg Gagne. I own a cottage behind the church. So far, what I've heard here tonight is there's no common sense discussion here. Just because the state says that, you're not liable for anything, that doesn't mean you guys don't have a conscience. There's going to be accidents there. There is no safe way to back out of that driveway into oncoming cars from both directions without having serious accidents there. The state doesn't realize where they're talking about. I'm sure they didn't come down and assess the situation in a busy weekend. And it's busy there for 6 months. People putting their boats in the spring, taking them out in the fall, bass tournaments, swim lessons that last for a whole month down in there. There's parking on both sides, whether you say so or not. You can't back out of your driveway with cars backed up onto the curb cut and successfully back out there. You can hardly drive out there if there's cars parked on your curb cut. And even if I don't know what I'm talking about, you've got the Public Works Director that spoke up against it. He should know what goes on down there. He must have some clout here. I just think you're not using common sense in allowing this to go through. I'm sorry, but that's the way I feel, and there's going to be accidents there. Thank you.
I'm very sympathetic with your concerns, but I think that your concerns should be something that you should take up with the state highway department, because they're the people that granted that, not us, see.
You guys know. You're the ones that know what goes on. You got a conscience.
Mr. Chair, could we have a little board discussion,
Oh, sure.
possibly?
Sure.
Just a couple comments I'm going to make. I also am sympathetic to how you feel. What we're charged with is looking at the shoreland zoning provisions, and we can only operate under what's written in these books. And you have every right to try to make changes to what's in the ordinances. Those things can occur. But for this current situation with Justin Hayward, we're looking at a request for a change of use. And it's a non-conforming structure in a non-conforming lot. So under Section 12, non-conformance, we have to look at C, non-conforming structures. It says C1A, after January 1989, if any portion of a structure is less than the required setback from the normal high water. Oh, sorry, I'm looking at the wrong, let me get you. Change of use, non-conforming structure, I apologize. And that is in non-conforming structures C4, change of use. The use of a non-conforming structure may not be changed to another use unless the Board of Appeals, after receiving a written application, determines that the new use will have no greater adverse impact on the water body, the tributary stream or wetland, or on the subject or adjacent properties and resources than the existing use. In determining that no greater adverse impact will occur, the Board of Appeals shall require written documentation from the applicant regarding probable effects on public health and erosion and sedimentation, water quality, fish and wildlife habitat, vegetative cover, visual and actual points of public access to waters, natural beauty, floodplain management, archaeological and historic resources, and commercial fishing and maritime activities, and other functional water-dependent uses. And also under D, non-conforming uses, change of use, number 3, an existing non-conforming use may be changed to another non-conforming use provided that the proposed use has no greater adverse impact on the subject and adjacent properties and resources than the former use, as determined by the Board of Appeals. The determination of no greater adverse impact shall be made according to the criteria that I just listed previously. So with that, if anyone has any comments on those things that I read about seeing that there's adverse impact based on those conditions, that's what we need to consider as a board. My only comments are that he has a current non-conforming use of a meeting house that people were fortunate there was only parking in that area on Sunday mornings that I'm aware of. Anyone else using it in the same use could have used it 7 days a week, 24/7. There were no restrictions on them parking on the sides of the roads. And it's changing now to a residential property. And the state has granted a permit for a driveway that has turnaround in the driveway, not on the road. And it is a residential zone, so based on that, I personally am comfortable based on what I'm reading for the ordinances that we're posed to consider.
The turnaround that you're talking about is not owned by Mr. Hayward. It's owned by the Department of Transportation. It's 33 feet, at least 30 feet that I'm aware of, and someone said it's 33 feet. That takes up more than half of the space coming out of his garage to make that turn. And in fact, anyone else can park there because it's not his land. So there's no turnaround to drive out of there. It's just not there.
I can't, the permit that he has turnaround on his property before pulling out into the road.
Not his property.
Ye-
He doesn't
yes.
own that property.
Yes, it does.
DOT owns half of his area in front of the building. So by
permit-
rights, that
Yeah.
section could be parking for anyone.
No, I appreciate what you're saying, but anyone on the board, please correct me if I'm incorrect. But the permit we received has in it a turnaround for someone to back out of the garage and turn around on the property before they approach 85.
Providing there's no car next to your driveway. which your neighbor's gonna have a vehicle there, which doesn't allow you to make that swing, even if that turnaround is there. You've got the other car in your way. You know, it's just common sense.
Unfortunately, we don't write the permit, and it's an approved permit by the state, granted. It's not under the zoning board of appeals to write a permit or change the permit.
It's a great idea, but it's not there.
Am I reading this correctly, folks?
Yeah, if I may add though, we did try to contact Nathan, and I both did try to contact the state. Nathan did get a hold of them. Basically, it was just saying that it fit their criteria. I don't know, I mean, we discussed whether or not they really knew what it was like in the summertime down here, but for them, they have a certain criteria that they look at, and that's what they go by.
Okay.
Would anybody on the board like to make a motion?
I move to accept the change of use for Justin Hayward for 584 Webbs Mills Road, from the current non-conforming use to a residential two-family use.
I will second it. Do you have a question?
Nope.
Okay.
Then all-
Seconded?
It's been
I
seconded?
seconded.
Okay. But you seconded. All in favor, raise the hand. It has been granted.
Thank you.
And I thank you very much. Okay. Now, part 3 is our workshop with Town Attorney Mary Costigan, Zoning Board of Appeals responsibilities, authorities, instructions, and procedures from Bernstein Shore Sawyer. And now I remember the Sawyer.
You have that drilled in your head.
Okay. I'll turn it over to you.
Hi, everybody. So, it's been a little while since we met, but most of you look familiar. Are there any new members? You're just one new member. Or both of you? Okay. So it'll be, I wasn't sure what to do in terms of being repetitive or what, and maybe some of you who heard this might want to kind of recommend the highlights to these guys, or if you want me to just go through everything, how would you like me to do it?
So do you have a set group of things you want to cover with us?
I typically cover, FOA and, just public meetings and decision-making and conflict of interest generally.
That would be great, I
Okay.
think, for all of us.
Yeah, okay. And then I know you had some specific questions, and we can go through some other specific questions.
Thank you.
Okay, so my general kind of very basic list for quasi judicial boards is, and these are always the 10,000 foot view that covers everything else, is to be fair, impartial, and unbiased, to let your personal feelings intervene, to apply the law like it is, whether you like it or not, and I think we had a good example of that tonight, to interpret the law but not rewrite it, to listen to both sides, or all sides, treat everyone before the board courteously, explain your basis for your decision, both at the meeting and in writing, make your decisions based on the evidence presented to you in this room and not based on things you hear outside of the record. Do not contact the parties outside of this room, and disclose any prior knowledge or relationships. If you follow all of those rules, you're pretty good. And I can go into more detail, but that's kind of the governing law of being on a judicial board, if you can follow all of those rules. So I'll start with the Freedom of Access Act and public proceedings, and that touches on a lot of those things that I just talked about. So because you are a board of the town of Raymond, you are a public board, and with that comes some responsibilities and some knowledge you should have about everything that you put in writing. Everything that you put in writing that is related to the business of this board is a public document. And any communication that a majority of this board has about a proceeding before it is a public proceeding. It needs to happen in this room. And that means that this board cannot communicate outside of this room by email on anything substantive or in the grocery store about anything substantive. You can email about, are you available next Tuesday for a meeting? And just basic administrative things, but you cannot communicate outside of this room about anything substantive about a matter before you. What you can do is if you have individual questions while you're reviewing everything, as an individual, you can email Scott and say, hey, at the next meeting, I need this information. And he brings it to the meeting, so you all have that information all at the same time in a public venue in front of everybody. And so there's certainly nothing wrong, because we'd be here forever if the only communication you could ever have with staff is in this room, because he'd be like, okay, well, let's leave and I'll go look at that and we'll come back in 2 weeks. So you certainly can do that. It's just that once a board, a majority of a board gets together and starts talking about it, it's a public proceeding, has to be noticed and has to happen in the public.
Can I ask a question along with that?
Yes, yeah.
When we do our walkthroughs,
Yeah, site visits.
yeah, it gets awkward sometimes because this case, for example, people come and they're trying to ask you all these questions, and we really shouldn't respond to
That's
any of
right.
that.
Yeah. So when you have, so it's a really good question. Site visits, an ideal site visit is something that all of you can make it to, that is properly noticed publicly, that anyone can go to. But when you get to the site visit, there's an announcement made to every member of the public that says, we are here to observe this property. It's either the applicant or the applicant's agent that is just describing what you're looking at, not making any arguments, not having any advocacy, but just, here's the building, here's where I'm going to put the driveway, so you can all get a visual of it, but it's not an opportunity for substantive questions. It's an opportunity for the board to ask the applicant, well, where was that going to be? Okay. But you're not talking about the law, you're just talking about it's fact gathering while you're there physically present and able to see. And this happens all the time, you're going to have members of the public who want to ask questions and just say, nope, you just have to say no. And you just have to say that this is the opportunity for the board to gather information. And if you have questions, save them. We'll be taking public comment and questions when we get to our public hearing. And that's it.
Okay.
You can say no and you should say no,
Yep.
and just keep it really clean. And then the other question that usually follows is, well, what if I can't make it and I still want to go look? It's not ideal, but you could drive by the property. You can view it from a public place. You can't meet individually with the landowner on your own. If you do a site visit on your own, when you come to the meeting, you're going to put on the record that last Tuesday I drove by the site because I couldn't make it to the site visit. I didn't meet with anybody. I viewed it from this public venue, and this is what I saw, just for the record. But you are not to go on the property without permission. You are not to meet the applicant or landowner on your own outside of the meeting.
Mary, can you take photos?
No. Nope. If you need photographs, you ask the applicant to submit them for the record, because you don't create your own evidence. You only review what is presented to you as part of the record.
Okay.
Can I ask a question?
Yeah.
I usually take them to the site visit, so if a question is posed to me to them, Well, last time I just told them to, if, basically when they're expressing their opinion, that they show up for, I told them to show up for the board hearing,
Yes.
but, okay. I didn't know if it was different for me as it was for them, because are they asking me as a code officer? or
No,
are they
same for
asking me-
you, because it's still, it's still, the point is the record should be developed in, I always think like the record should be developed in this room. When you're on a site visit, you're just getting a visual, so you better understand when the evidence is presented in this room.
And that's why we're not supposed to talk even amongst ourselves. We have to wait till the meeting
Exactly.
to talk.
Yeah. Yeah.
Just get clarifications on the site itself, so we understand, so
You
we can make decisions here.
Exactly. So tonight was a good example. So say safety was something that you reviewed, and say you had some standards, you would be standing on the road, you would be standing at the edge of the driveway and looking at whatever you need to look at. You would get a much better idea of where that was and be able to ascertain and be able to judge that by seeing that. That's an example. So.
Okay, so going forward, that part of the ordinance that talks about public health has nothing to do with public safety.
Correct.
Public safety is a completely separate issue, and we have nothing on public safety?
Actually, we do in the regular land ordinance, but not in
Not-
shoreline.
There's a site plan standard of safety. But
that
that's
doesn't
the
fall
that's the
under
planning
what
board.
we
That's the
would-
planning
Right,
board.
so this
Planning board
particular,
would-
yeah,
Right.
so this.
Sorry,
so
is there
I'm
another-
sorry, so-
I think in appeals, it does lift, it uses the word safety.
Non-shoreland, but
Yeah, not in shoreline,
Okay.
but for basic land use, regular land use, I
for
think. I'd
an
have to look
appeal,
at it.
yeah.
Yeah, on an appeal.
Oh,
But
okay,
so
but
let-
for what we were talking about, because, so just this conforming, non-conforming, this particular issue, we had no public safety
Correct.
guidelines or in the ordinance
Correct.
that we could address.
Correct.
And that's why we could,
Right.
we were only approving what Joanne had read, so this way the public was satisfied with the fact that this is what we were looking
Yeah.
at.
And speaking very generally, most of the time, those types of issues are a planning board issue and not a zoning board issue. Because you're talking
Right.
about a site
Right,
plan
that's
and,
what I-
yeah.
Okay.
Did you say the public was satisfied?
I mean, as you, I thought you did quite well with trying to satisfy everybody by, clarifying, this is what we're looking at, this is what we're being asked to, decide on, approve. It wasn't anything else. And we had no control over anything else.
Right.
And we did, the whole purpose of asking you the question with regards to the driveway, because that was in question
Right.
the last meeting.
Yeah.
And as you could see that it was still in question with regards to the town and not taking action on, a particular situation that could be public safety issues, and it was a DOT approved driveway plan
Yeah.
and that we had nothing to say about it.
Mm-hmm.
But we wanted to make sure of that. So,
Yes. Yes. If you recall, a little side note, the ferry parking lot
Oh.
was about safety.
Yeah,
That intersection.
we recall that. Yeah. Yeah.
okay.
Yeah, that was about safety.
Yeah,
Okay.
yeah,
But there was a lot of evidence about intersections and safety.
right.
Okay. The record, so Mary takes some nice notes for you all. It's not, it's part of FOA, but it's something that I also really like to go over, especially if you have, it should happen no matter what, but particularly if you have lawyers in the room and it looks like it's going to go to court, right? That's when it really matters what your written decision says. And your written decision should be talked about as the board. So if you have multiple standards to consider, a variance, for example, that's easy because you break it down, you have your four, and for each standard you're going to have a discussion first about why you think it does or does not meet that standard, and then you'll take a vote on each individual standard, so there's a very clear record. So the applicant knows exactly why the application was approved or denied, and any interested parties know exactly why, and then a judge will know exactly why. And sometimes it seems like a pain and long, but think about if a judge doesn't like what you wrote and sends it back and you have to do it all over again. Because that's what happens if it's not done the right way the first time. If you have something that's really complicated and I'm here or Phil is here at the meeting, what I've done before is just take a straw vote and not a final vote, and it's for guidance for the attorney to go and write a written decision to bring back at the next meeting, and it's the next meeting that you'll all make a final decision. And the reason for that is because that 45-day appeal period is triggered on the date of your actual decision, not the written decision, but just the decision. So if it's a few weeks before you can meet again, that eats into the appeal period. And a long time ago when I was at the City of Portland, there was an appeal in that middle period. So they appealed before we had the written decision out, and the judge was like, this is a mess, you know. So it's just the way it's written. So just depending on if you ever get something that's super complicated, you could do that. But you should always be in the habit of really having a good discussion about the reason why you're deciding the way you're deciding. Tonight there was a little bit of that, but it was mostly a motion approved, and that was it, you know. It's important when there's opponents. It's really important if you deny something. It's actually in the Administrative Procedures Act that if you deny something, your reasons for denial have to be in writing and given to the applicant. So you just get in that habit of, and it's difficult, and there's a lot of silence, and there's a lot of but it's important.
Yeah, there was last meeting, it was a long meeting, and it was discussed in thoroughly. That was only one thing holding everything up, that one question.
Oh, so
Yes,
all
that
right. So
was
you,
good.
Yeah,
you already
it was
gave
thoroughly
you gave your
discussed.
reasons last time.
Oh,
Yes, got
Yeah,
it.
yeah,
Okay,
we were waiting.
got it.
Yeah. We just did, there was that uncomfortable, you know, just, we have
That-
that clarification.
that last
We'll feel
issue.
secure in the fact that we're
Got it.
doing our due diligence and job right.
Right. Executive sessions, there probably isn't a lot of reason for you to have an executive session unless there was a reason for you to meet with the town attorney about legal rights and responsibilities that if there was an anticipated litigation, really is the only time we would do it in closed session. Like, this is a public session, even though I'm advising you, but I'm not advising you about a particular case that could be sensitive. So.
And anyone in the group can request that? Is that, how does the executive session?
I mean, it would be very rare for a Board of Appeals to have an executive session. It would have to be something so sensitive that I couldn't advise you in public, and it would be very rare.
Okay.
And it would be more of a, it's really not that anyone would request it. You would talk about it. It would probably go through Scott. He would call me, and I would advise you as to whether it would be appropriate or not. I don't think I've ever had an executive session with a Board of Appeals, but I imagine there could be some circumstance.
We'll keep that straight.
It's usually with the Board of Selectmen. Again, public records. So another question is, you get a lot of paper for all of your meetings, and do you have to hang on to all of that? No. As long as there's one master copy that's at the town, so there's a file with all the application materials. If there's anything that I'll get into this next for a little bit. You should not be doing any research on your own, but if there's anything that this board relies on, you have to make sure that that's in the record that is then in the town. So you can only rely on what's in that record. Any electronic emails that you have you don't have to hang on to emails that say, yes, I'm available next Tuesday. But do you have town emails, or do you have personal emails?
Personal.
Personal. Do you have a filing system? Do you have a file for Board of Appeals that you can
I do.
throw emails into? That's a good practice.
But everything, just the agendas and all that stuff?
Yeah, I would,
Okay.
Make a habit of it. Not every single little email, but sometimes someone will, this is also rare, but it happens, where there's a freedom of access request for all emails related to, it's usually, and I'll talk about conflict of interest later. So if it generally arises in a situation where someone thinks that there was some sort of conflict of interest or some sort of funny thing going on with the board, and they sued the town because they lost, or and they want to prove that there was some bias in the decision. So they will ask for emails between board members about this subject. And it's much easier if you have all of your emails in a folder. And hopefully none of those emails are shady.
Those are another folder.
Right? Those just get deleted. No, those don't happen. But yeah, so it's much easier when you can just print it out from that and just give it over to Scott or Mary and say, here you go.
I think, was it not too long ago that, was it recommended that we have a town email?
It's definitely
It is.
recommended that you have a town email.
I'll talk to Kevin about that.
Okay,
Yeah, that would make your lives a lot easier.
okay.
Yeah. All right, so let's talk about this, the concept of having to make your decision based on the record before you and not based on any research outside of the record. So there may be a complicated case that comes up and you don't quite understand it, and your instinct is to go home and Google all about it and find out all sorts of information. Well, the problem with that is the information that you find could persuade you to decide a certain way. And you could come back to the next meeting and say, well, I did some research and Google told me this, and so I'm telling you, everybody, I think we should all deny this because of that. And I'm not saying you would do that, but that's what you should not do. And instead, if you have questions, you ask the applicant to provide further information, you ask Scott to provide further information, you ask me to provide further information. So a neutral party, or the applicant, is giving you that additional information that you feel you need to make your decision. And that way, everyone is getting the same information at the same time. Again, you can pose questions by email to Scott, because you know what, we're really missing this information. It would be great to have it, and then he can ask the applicant for it. And you can certainly do those types of things. Don't copy everybody, just send it directly, and he can report back at the next meeting. Any questions about sort of the record and public proceedings or public records?
Is the video kept of the meetings?
It is the official
It's our
record
official.
of the meetings,
Yeah.
and they are kept, there's an archive of them, they're online. And if you go back further and they're not online, then they are accessible, and CDs are available through the town office.
Thank you.
Okay. So conflict of interest. There are different levels of conflict of interest, and really the statutory definition of just conflict of interest, and the reason I say that is because most of what comes up is bias and not necessarily conflict of interest, because conflict of interest has a specific definition in the statute. When the board member is an officer, director, partner, associate, or stockholder of a private corporation, business, or other economic entity, which is the subject of the issue before the body, and the individual is directly or indirectly the owner of at least 10% of the stock of the private corporation, or owns at least 10% interest in the business or other economic entity. So if you own a business and they're before the board for a variance or a permit of anything, that's a conflict of interest, and you actually cannot participate. You don't have a choice. You have to recuse yourself in that circumstance. There are other circumstances where there's an appearance of a conflict of interest or an appearance of bias, and those are situations like, well, we went to high school together and you never really liked me, and now that I'm before you, I don't think I should do this. Or 5 years ago, I put steps on that house, or all these small town, everybody overlaps and everybody has some sort of relationship at some point to an applicant. It happens. And what you do in those circumstances is you are open about that relationship. And at the very first thing of the meeting, before the board starts considering the application, you say, Chair, I'd like to talk about a potential conflict. This is the situation. I do or do not think that I can sit here and in an unbiased manner review this application, and I do or do not recuse myself. If you don't think you need to recuse yourself and you think that that you can do it in an unbiased manner, the board says, thank you very much. Let's take a vote as to whether you think he or she should participate in this application. And that's very open, honest, clear, and upfront. And that's how you should deal with all matters of potential appearance of a conflict. No matter how small, even if it's really small, it's worth just raising, because it always turns into count 2 in a complaint. And you just don't want to create that count 2, just to give them something else to talk about. Bias is also related to that doing research outside the record, or appearing like you have already have an opinion about how this should come out. I think one of the first things that I read is that you don't let your personal feelings intervene, so that you live in this town and you could think that that application and that driveway was the most unsafe thing you've ever seen. Doesn't matter. You have to forget that you care about whether you think it should be approved or not. It's only the rules that are in front of you, and it actually, I think it should give you some comfort, because you can explain to the public that you have no choice. If somebody's able to check all of the boxes, you cannot say no. You have to say yes.
And that always seems like the hardest thing for people to understand.
Yeah.
When they don't like something that, yeah.
Right. I mean,
Yep.
we all told that gentleman today what the deal is, and you have no authority to determine whether that driveway is safe or not. And he's la 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 la.
Right.
But it's really to give you some comfort that you're doing your job. If someone checks all the boxes and they approve it. If someone checks all the boxes and you deny it because you don't like it, a court's going to say you're wrong.
When the public is here, though, each time, like even though they were here the last time, it's important that we let them say their piece.
It depends. It's not, I mean, it's much cleaner if you have presentation by the applicant, questions by the board of the applicant, public comment, open, public comment, close, done.
So because we'd already done it last week?
You did not have to do it tonight.
Okay.
Unless there was something new tonight. But if there's nothing new and it's the same, you're just asking a question for me, the public doesn't really.
It wasn't new, it was just the question was
Just
being
getting-
answered,
yeah.
but that was already discussed.
Yeah,
so,
you did not have
okay.
to allow public
Right,
comment
right.
tonight.
Wasn't sure how much you interact with that,
Yeah.
but
Right.
It's,
Okay.
I
yeah.
wanted to make sure you understood all the information though as well. that you
Yeah, I mean,
had.
and the idea is just to make it really clear from the front,
Yep.
from very upfront. This is how we're going to do it. This is your public comment. And then once they're done, you say any other comments? Public comment is now closed. And tonight you would have said, we're done with public comment. You can even put it on the agenda that there'll be no more public comment, so people aren't coming in anticipation of being able to say anything. And then you can say, the last time we had public comment, we stopped in the middle of our deliberations because we had a question. This is a continuance of our deliberations. And it's more about creating when you create the expectation, then it's much easier to manage. And they're raising their hand, and you can just say, no, I'm sorry, you had the opportunity at the last time to comment. This is, oh, absolutely.
Okay.
Yeah,
All right.
absolutely. Yep. Even tonight, he stood up for the second time when you were deliberating.
Very
You
clear.
could have said, we're done, thank you. This is not
Okay.
because then it gets into this kind of
I know,
back and
that's-
forth, and
yeah,
that's not what
that's
it's
why I
about.
wasn't sure. It's like-
Emotions and everything
Yeah,
else, just to
yeah.
I
kind of
wasn't
dip it.
even sure if I should try
Respond,
to explain that
right,
with the
yeah.
driveway, but I wanted to
Yeah.
make sure the
Yeah.
And-
proper information
Right.
was out
And
there.
you know,
Yeah.
it's good to practice in when you only have 2 members here, because
Yeah.
if you have a room full of
Yeah,
people who want to talk, you need to control that. And the way you practice it is in the easy small ones. You don't do that for the first time when you have a
Okay.
big room, because then you're out of practice. And someone stands up and the next person, well, let him talk and I have to talk, and and then it gets a little wild.
Yeah, the crowd was smaller, the angry crowd about the driveway this time.
Okay. So predisposition, bias, relationships, there is a disqualification, and I have to, a relationship by consanguinity or affinity within the 6th degree. So, if it's your cousin in the application, you're a relative and you need to recuse yourself. Yeah, there's a statute, disqualification. Within the degree of second cousins inclusive. So if you're related, just recuse yourself.
yep. Back away.
Let's see what else. I think that's pretty good in terms of very broad advice in terms of being unbiased and open and transparent. Do you want to talk about you had a couple of specific questions about your ordinance.
Variances.
Yeah.
We just, we get a lot of setback reductions.
Yeah.
We
For
just
single
want-
family dwellings, right?
Yeah.
Yeah.
I just wanted to understand when someone does have to prove hardship, is that only when their request is beyond what we're allowed to do under the setback reductions?
For single family, yeah.
Yeah.
So the default is for a variance, you need to demonstrate that you meet the hardship criteria. And the single family setback comes from the statute. So the statute lays out and your ordinance. So it lays out, and the ordinance just mimics the statute. So it lays out the variance criteria, and then essentially what it does is make it just a little bit easier to get a setback variance for a single family home. But every other type of variance that you need, you have to meet the hardship criteria.
Because I have always been told and understood even before I was on the board that if someone was requesting a setback reduction, they only need to consider, that's what I make sure we haven't totally
Yeah.
misunderstood this, or I haven't. Under section 16 administration, there's variance
16,
appeals.
I'm in your Board of Appeals, section 6.
Page 53 of 70
Oh, you're
under
in
shoreline
You're in
zoning.
shoreline zoning.
Yeah.
Okay, I was in the
Sorry,
land use
yeah.
ordinance. Okay.
Yep,
And on the garages and things.
yeah,
Yeah.
exactly. It's like variance versus
Or,
What page are you on?
53 of 70, if my book's right.
But section
Section
16?
16, 2 variance appeals, and then there's
okay.
A, B, C, D, E, F underneath it.
Yeah, oh, I see, yeah.
So the way I've always understood it is if they're asking for a setback reduction that's basically half of what the normal variances are, normal setbacks, if they meet all the requirements under F, we can allow a setback reduction. That's how we've always looked at it.
This says can only be granted or only available for lots with a residential dwelling as the principal structure.
Yeah, correct.
She was looking at what's the criteria when they go down to, is there a criteria that they go through? Is that what?
Well, no, because we had, like on the applications themselves, it gets confused because we have an administrative appeal, we have a variance,
Yeah.
we have a conditional use permit, we have a variance provision for non-conforming, and then setback reduction.
Yeah.
And the only one, it says variance, is the only one where it says information listed on the page must be submitted. And I think that's where you prove the hardship criterias.
Mm-hmm.
So that's why, like I said, it's always been explained to me, if they're just coming for a setback reduction, which is, you can get 15 feet from the front, 10 from the side, or 15 from the rear, which is half of the normal
Yeah.
setbacks, then we just need to consider the criteria under 2F and not consider whether there's undue hardship for needing it to begin with.
Right. But so first, this is only the shoreline provisions.
Yes.
Your regular land use provisions are actually clearer.
Okay.
Yeah.
Okay.
Might be something to look at when we change the ordinance to
Yeah.
kind of clear it up, because there are some
So-
other issues.
It's Article 6.
Yep.
The Board of Appeals. And it follows the statute. I might need to, it sounds like I need to work with Scott to clean up the shoreline zone provisions. Because the provisions in Article 6 are correct.
Okay.
And they're clearer. And it talks about, so it's B, powers and duties,
Under B.
under Article 6.
Yeah.
And then
Oh, okay.
1B is variances.
Yeah.
And it's undue hardship. And then C is a setback variance for a single-family dwelling, where it makes it a little bit easier, and it says undue hardship shall mean this, so they have a different set of
Okay.
criteria for a
Okay.
single-family dwelling.
Because we always have shoreland. It's always shoreland
Yeah,
zoning that we
it's-
get.
Since I've been here, that's all
No.
I've
Yeah,
had
it's been
so far.
garages and, what was the other, a bunkhouse?
Yeah.
A bunkhouse
Yeah.
and a garage
Yeah.
that it wasn't like, the dwelling was already existing.
Yeah.
Yeah, they just didn't.
So-
I'll work with Scott. It may be that your ordinance is problematic.
Okay.
According to state law, those are the only variances that you can issue. There is a practical difficulty variance, which is yet another level of a little less stringent to get there. But it seems like you need some clarity in your shoreline zoning provisions.
Yeah, because
Yeah.
even as an applicant myself, I was told you don't have to fill out, you have to worry about the undue hardship piece if you just can stay within the setback reduction criteria. So,
Yeah.
no, that would be great to have that cleaned up.
I have a question or two, but go ahead.
Yeah, and it's vaguely in my head that those kind of general setback reductions have been perhaps said by a court that it's not permitted under the statute. But
Really?
I'll
Yeah.
work on that with Scott to see if we need to make any changes.
Because that's, yeah, I certainly,
Yeah.
that makes a big difference if we need to start with the hardship
It
piece
does.
and make sure.
It doesn't. It also doesn't really make any logical sense why you would be able to do that in the shoreline zone, but
I just thought I heard
nowhere
once
else.
that
Usually in the shoreline zone it's more stringent.
I know, exactly. I had heard, well, the restrictions they were so difficult to begin with, it was to give some leeway to people,
Sure.
to give them a little bit of room, but
Yeah.
Does
Yeah,
it make any
I'm listening.
difference? For a long time, this town didn't have any enforcement or codes.
Mhm.
And for instance, it's always been brought up at Thomas Pond Terrace. Clifford Swan developed it, and he put all the 50-foot lots. And the difference is, like if someone bought a lot before there was a law passed about setbacks, or if someone purchased the lot after and fully knew that those setbacks, can you be more lenient with the person that had it before than the person that bought it, and when this, knowing that these setback laws existed?
They would need a variance.
They what?
They need a variance.
Yeah.
It
The
do-
same.
So when you buy property, the only thing that's grandfathered at that time is the lot, because that's all you have unless there's a structure on it, right? So the guy tonight had a non-conforming lot and a non-conforming structure. So there's two different things. If you just buy a vacant lot, that you are grandfathered as to the lot dimensions, the area, the road frontage. But if you don't have a building on it yet, you're not guaranteed the setbacks that were in effect at the time because you haven't built anything yet. If you go to build something and your lot is so small that you can build a 12-foot wide house, you come and you get a variance. And you should, in that circumstance, most of the time, you can meet the hardship requirement unless you're on the waterfront and you have another use of your property under under case law that you can use it to launch kayaks. And that's just what happens. If you buy property and you let it sit, the rules are going to change, and everyone's on notice that the rules can change from underneath you.
And I think in the shoreland, it's one of the things we could go over is that the setback, you can only get a setback if there's already a principal structure on there. So if they have a vacant lot and they come in for a house, would they still be able to go for a variance, or would they be not allowed where there's no principal structure on there to begin
You
with?
can still ask for a variance, but you probably wouldn't get it.
Okay.
Because there is a case out there, I can't remember the name of it off the top of my head, but it was dealing with the hardship criteria with the economic return on that standard, and that property, the court said, well, it's waterfront property and you can use it for recreation, and you can use it to launch your kayak, so it has some value. It may not have a house on it, but it has some value. Yeah.
So can we make sure if you do look at the shoreline
Yes,
zoning,
yep.
that we look at the application as well?
Uh-huh.
Because it almost seems like then setback reduction should be part of the variance one where it says the information listed must be submitted as well. which
Okay.
That's where I think they fill out the hardship piece of
criteria.
it, yeah. I think anyway, just something to consider.
Yeah.
that you can-
No, I think that's a good idea to look at those.
My question is, I was always told that if they ever got a variance for a setback, that it runs with the land?
Yes.
Okay,
Yeah.
that's what I thought.
Yeah. The only setbacks the only variances that don't run with the land is like a handicap structure variance. You can limit that to the time that the person who needs the handicap ramp or whatever's going on there is living in the house, or as long as they own it or what have you. But that one doesn't have to run with the land because the next person may not need it.
So to be clear though, going forward, we should consider a setback reduction, anything. It's all part of variance.
Well,
Variance.
I think going forward, you should continue to follow the ordinance.
Yeah.
I'm going to go back and look at it more thoroughly and give some direction as to how to interpret it, and also talk about how we should change it.
And we'll look at the one in section 6 though, just to
That's
make
much
sure.
clearer.
Yeah,
And
that'll
that
help. Okay.
follows the statute of you can get a setback reduction for a for the construction of a new single-family home.
Okay.
It's also called a variance, but it's just easier criteria to me,
But you can get a reduction for a garage,
only if it's attached to a single-family home, I think.
right, if it's attached to the.
Yeah, I think there was something in there anyway that was for a garage.
Right, it had to be
Yeah,
attached.
it had to be
on the
attached.
other one, yeah.
Yeah,
Yeah.
Could I ask you this?
yeah.
If, say, on a shoreland, you say a shoreland lot that becomes unbuildable, but you can have recreation, then can you go and demand that the valuation be reduced because you can't build a house on it?
Sure, yeah. Well, you can't demand. You can, you can request an abatement, is what you can do, based on the fact that that is not a buildable lot, if it's valued as a buildable lot. Yeah. Yeah.
Are you getting ideas or something over here? What's Larry up to?
No.
Because I did have a gentleman come in and bought a 40-foot wide lot and the 20-foot setbacks, and he wanted to know what he could put on there. And it states that even an RV has to meet setbacks.
Oh, wow.
So it's like even if he came in, I meet him for a variance on that, I don't know if he'd be able to put anything on there. But that was just recently.
30-foot lot.
You know, it's like, you try to, he said that, well, long story short, but yeah, I just told him I don't know what you could do there. If you could put it, 'cause even it says even a tent has to meet setbacks.
It's a structure.
Yep.
I had a question
Yes.
related to the one tonight, a change of use. It just got me curious about if his use was non-conforming. So if he's asking for a change of use to a residential, isn't that now conforming? The use is conforming?
Yes, so
how does that-
I have to say, when I came here tonight, I was not well versed in that application. I
Yeah.
knew about the driveway question, but
Yeah.
I did not know about kind of the substance of what the change was. So the actual application before you was for a change of use in the shoreland zone?
Yes,
Okay. So non-conforming use,
yes.
that's usually in the front, right? There we go.
I just wondered, because the use was now gonna be an appropriate use for that zone.
Yeah, it's also a non-conforming structure too, it's
Yes.
both, yeah. Yeah, what you were doing was change of use of a non-conforming structure,
Right.
As
And
opposed-
can change, is
as
it the one,
opposed to,
is the one right after it is,
right, if someone was going, if he was in a conforming structure and he was going from a non-conforming use to a conforming use,
yeah.
he wouldn't need, I don't think he would need your approval.
Well, that was my question,
Yeah.
because,
This
the
is
other,
an existing non-conforming use changing to another non-conforming use.
well, that's, I kinda wondered if,
He was here before you for a change of use of a non-conforming structure. Because that's any use, any change of use has to go to Board of Appeals. That's out of, C5.
well, I read both to cover it, but.
Yeah, yeah,
Well, okay, so if he was here just for the,
right. If it was a permitted use that he wanted to, he would just go see Scott.
Right.
Right, unless it triggered planning board for some reason.
and it's change of use of non-conforming structure, because he's changing the building to a two-family? That's the structural piece, and then but the use piece is just because it was a meeting house and now it's a residential. Okay, all right, sorry, I had to follow.
Yeah, no, it's confusing when you have both a non-conforming use and a non-conforming structure. Yep, very similar review criteria.
Okay, that's good.
Yeah.
Thank you.
Sure. Any other questions?
Mary, could you give us your definition, because I'm a little unclear on it. What is a conditional use permit?
Conditional use permit. Where do you have your, is this just shoreline zoning? Do you
Yeah, it's
have
just
land use?
shoreline, so we have,
So in your land use code, I'm assuming that means you have conditional uses?
yes, and not just, yeah, or anything that's not permitted within that zone.
Yeah. So you'll have to forgive me because I work with a lot of towns, so I don't know Raymond's land use code off the top of my head. But generally speaking, if Raymond does it this way, and this is how what a conditional use is, you have in your land use, do you have the land use code?
Mm-hmm.
Okay, if I can see that.
Glad somebody came prepared, I did not.
Yeah. I thought the Board of Appeals section did that. Okay.
Yeah, I should have grabbed the both of them, I didn't think about it.
All right, so this is the land use code. Where are the uses? District regulations.
Seems like we're always getting shoreline zoning stuff.
Hmm?
Does it seem like we always get shoreline zoning?
And
There's
then-
a, there's, I think there's a specific
And then
section.
there
that
should
does-
be a section
Yeah.
on
One that we did for the
conditional
lot that was
uses.
shoreline, but it was a bunkhouse. It wasn't connected. It was across the street. And we were approving setback.
I remember, it seems
We
like
talked-
there's,
No, it was, we were on what we did, like I said, based on what we, how we read it and all.
Okay.
But
Site
in the
plan.
future, what we, if something like that came up again, we'd have to just make sure we go through the hardship standards.
So each time?
Evidence, that's what it
That's
sounds
when
like
you
it
got
might.
on. This
that's
has
what-
been the question?
Right, no, but that's what they're gonna let us
Okay,
know.
alright.
That's what it sounds like. Maybe I don't have it in there.
I'm
I
getting
think
there.
you do, I think you just gotta,
Yeah, I just have to find it. I don't have
Good
it.
luck. That's why I put
Here we
stickies
go,
in.
that's conditional rezoning, I don't want that, I'm getting there. Amendments.
When we're doing motions, you don't like it. You never say.
trying to remember.
Someone else has to second the motion, you're the chair. Okay, just so you know. Just so you know, that's why I was going, no, I was
She's gonna
You're the
keep us
chair.
on.
You're the chair, you're the chair, you don't.
You're supposed to keep us on the line.
So I will say that step number one, and we're gonna find step number two, is when you look under district regulations in the land use code for each district, so for example, here's the rural district, right? You have permitted uses and conditional uses. So conditional use is a separate type of use, and if it's a permitted use, you are just allowed to do it. Some, you know, standards may apply, but you're allowed. If it's a conditional use, you have to first meet a certain set of criteria in order to do that. And it usually, those criteria, which is what I was looking for, usually have to do with impacts to the neighborhood. So it's a conditional use. And the reason, here's a neighborhood grocery store, right? It's a conditional use because it might be allowed, but we don't really want it to be automatic. We want to make sure that there's not too much traffic for that neighborhood, that you're doing it the right way, that if it's a conditional use, we could put some parameters around it, maybe hours of operation or something to not make it quite automatic. It's kind of like a maybe category.
And does that come under this board?
Yes, I think so. I said that quickly. Typically, yes. So yes.
I believe it does, yeah.
I think maybe in the past, they've had some things like somebody in the residential zone wanting to run a
Almost
business,
like they
and
put
there's
it
been
in each
conditional
individual.
uses, like people
They
who run
put-
a business must
They
be
put
people
conditional
that live
uses,
at the
but in terms of
premises,
the
right.
procedure for
That
getting a
way,
conditional
and,
use
I haven't seen it, but I
approved.
think I've heard of it.
I believe I can read.
Board of Appeals to hear grant.
Oh, is it under there?
Well, it's starting on
Right across
page
from the
24.
Oh, so you're way down low.
You're
This
downhill.
just deals the grant or deny applications for conditional use
What's that, like
permits
halfway down the road?
as
More than
specified
halfway down
within
the
this ordinance.
Yeah, you have, and I'll look, so under the board, you have hear and grant or deny applications for conditional use permits. In granting permits, the board may impose such conditions as it deems necessary in furtherance of the intent and purpose of this ordinance. They run with the land, but I don't, let's see if there could be
Criteria is on
criteria.
page 35.
Is it within Article 6?
It is Article 9
Okay,
for minimum standards.
okay. So what section is it? It's A?
Yep.
Okay, there we go. That's why it was on the back of another page. So, for conditional uses, the step number 1 is it under the category of conditional use? And step number 2 is Article 9, Section A, which says the Board of Appeals shall approve, deny, or approve with conditions all applications for a conditional use permit, and it has all the standards in here. Compatible, not noisy, doesn't cause pollution, doesn't adversely impact deer wintering areas. So there's a whole bunch of standards here that you would look at.
I'll read it, thank you.
Yep.
That's good.
Get that back to you. Okay. Any more questions?
Any more questions?
No,
Great.
Thank you so much.
All right.
Thank
You're
you.
welcome. Sorry?
thank you.
Oh, you're welcome.
Mary,
Yeah.
you know who was responsible back in '51? Sidney Wernick. Do you remember him?
No.
He was there. He was at your firm
In 51?
in '51.
I wasn't even a twinkle in my mother's eye in 51. Maybe his picture's hanging on the wall somewhere.
It's
I'll go
somewhere
take a look.
down there.
Where are we at, Larry? I think we need to,
Oh, adjournment. Do I?
or
Wait,
does
wait, wait.
Scott?
Oh, Code Enforcement Officer Communications.
Night.
have-
Thank you very much.
Yeah.
We have nothing coming up, and nothing's come across for any appeals yet at this time. I
Okay.
thought there might be with a building permit, but nothing as of yet.
By a building permit, do you mean like one or?
Well, they would appeal my decision because I issued a permit. Building
Okay, it's a one-unit thing. It's not.
Yeah.
Are we getting any tracks of? I see in the paper, like down in Wyndham, they're getting like 6 units or 10, or they want to put in 10 houses or 6 units. We don't have things like that coming up.
Well, something like that would probably come under, as far as individual houses, you mean? That would come under subdivision, which they'd have to go
Okay.
through the planning board, through that process, and
Okay,
stuff like, anything that, yeah, like that, it would be a minor
would be
subdivision.
planning board first.
Yes.
Okay.
But other than that, there isn't anything coming in front of the appeals board, to my knowledge.
Okay. And then do I hear a call for an adjournment?
I move to adjourn.
Second.
Second.
We just.
All in favor, raise the hand. We are adjourned.